for advancing to the semifinals, which is a great achievement in the first place. So you are among the 4 best teams already out of more than 50 universities. So today we will try to give you a hard time. And for the introduction, as I said, my name is Annett Rombach. I am an arbitrator at CAS and an attorney at law in Frankfurt, Germany. And I will ask to my co-arbitrators to introduce themselves. They are obviously most of the 2 esteemed and outstanding CAS arbitrators, but please, Luigi, Efraim, introduce yourself.
Okay, thanks, Annett. Luigi Fumagalli, professor of law and attorney in Milan, a CAS arbitrator. Thanks.
Thank you, Annett. Well, I'm not sure that I'm esteemed. I'm sure steamed because it's very hot sometimes during the hearing. My name is Efraim Barak, a lawyer in Tel Aviv and the CAS arbitrator.
Okay, thank you very much. Then before we begin, briefly some housekeeping issues. Have you come to an agreement as to the organization of your pleadings? Maybe Appellant first.
Madam President, yes, we have. We've come to an understanding that the appellants would go first and deliver all issues, followed by the respondents delivering all of theirs. But we also felt that given it being a semi-final, we would increase the time allowance to a total of 22 minutes for both individuals in a team to deliver the procedural and merits issues. And we also would like to request 90 seconds for the rebuttal.
Thank you very much, Counsel for Appellant. Counsel for Respondent, can you confirm that this is the agreement that you have taken?
Thank you very much, Ms. Rombach. Yes, this is the agreement we have taken.
Okay, thank you very much. And I'm looking at my co-arbitrators, whether they have any objection as to this agreement. If not, I think then we can move forward on this basis. Just as another housekeeping issue, and for you to let you know, we are going to ask questions whenever we have one. So whenever me or one of my co-arbitrators wants to know something, we will chime in. We will be prepared depending on the length of the questions and answers to give you additional time, of course, fully adhering to the equality of the parties. And with these introductory remarks, we are ready to start, and I give the floor to Counsel for the Appellant.
Madam President, members of the panel, I appear on behalf of the appellant, and this is an application to appeal the sanctions imposed on our client, Mr. Rattam, in the case against FIFA. The appellant makes his application in 2 parts, as we've said, and we do intend to follow the structure set out on our skeleton, which means that I, Jonny, Kilgallon, will be going over the procedural issues, and my colleague, Mr. Kaluza, will be going over the merits issues. We will now deal with each of these grounds in turn. In relation to issue 1, which is whether or not the CAS has jurisdiction to hear the appeal proceedings today, we simply state that the appeal is admissible. And we state that in accordance with R47 of the CAS code, the statement of appeal was filed within 21 days of receipt of the FIFA appeal decision under Article 57, subsection 1 of the FIFA statutes. And that, for your reference, members of the panel, is number 1 in our bundle. And accordingly, the CAS should apply the FIFA statutes, FIFA regulations, and the FIFA Code of Ethics, and Swiss law shall apply on a subsidiary basis. However, we are aware that there may be a wrinkle or two between us and our respondents. And with respect, I would like to divulge into this issue a little further. With reference to Exhibit 6 of the SAM bundle, which is the FIFA appeal decision, specifically referenced to page 13, we can see that at the end of the decision itself, FIFA does invite Mr. Rattam to appeal the decision under Article 58, subsection 1. And we do submit, it does seem a fair move to mislead our client and then to go back on the word by saying that they do in fact not have jurisdiction to hear this case. And indeed, I know the respondents will be familiar with some of the CAS jurisprudence from their bundle. where issues have been taken to the appeal committee first before going to the CAS. And in the respondent bundle, they have number 6, Blatter against FIFA. But then also on the respondents list 11, page 8, paragraph 33, also makes mention to Chung against FIFA and Platini. With that background, we do wish to explain why the appeal is actually admissible today. So Article 82 of the FIFA Code of Ethics states that general rule that decisions of an adjudicatory chamber are in fact final and should be applied directly to CAS. But with reference to 81 of the Code of Ethics, there are exceptions here. And that is that decisions concerning Article 29 can be appealed to the FIFA Appeal Committee before going to CAS. And what is Article 29 of the FIFA Code of Ethics? Well, that is, we should consider the facts of our issue fall in line with the manipulation of a football competition, of which the World Cup is certainly one of those. By doing the above, we submit that the appellant has actually exhausted all available remedies under R47 of the CAS Code. Moving to issue 2 with the challenges in relation to Mr. Vax and Professor Umaima, the grounds for the challenges of both arbitrators in relation to breaches of Article 33 of the CAS Code, which is at number 4 in your bundle for your reference, but you don't have to read that one, I'll read the important part for you. It reads that every arbitrator shall be and remain impartial and independent of the parties, and shall immediately disclose any circumstances which may affect his or her independence with respect to any of the parties. Our challenge has also been submitted within the 7-day period as stated within R34 of the CAS Code. But we also state that by objecting to 2 of the arbitrators, the appellant has not freely waived his rights to a free trial under Article 6 ECHR. And it is well established that the application of ECHR is indirectly applicable in CAS proceedings, as shown in number 20 of our bundle, Adamo against FIFA, paragraph 66. I can familiarise the panel with that paragraph if they so wish, otherwise I will continue with the submissions. With this background, each member's violation of R33 of the CAS Code will be addressed in turn. Mr. Vax's disqualification, the reason for it, stems from the LinkedIn post on 20th of November 2021, which was discovered by the appellant 3 days before this hearing. Now, the post criticises the COVID-19 vaccination movement. Arbitrator, you're on mute, but I think you have a question. Are you okay?
Yeah, you're on mute, Efraim.
Efraim, you are still muted.
Okay, sorry, I was muted. Yeah. No, before you go ahead, can you explain us why do you think that we, the panel, have at this moment in time the power, authority, or in any way decide this challenge? Even looking at R34 that you very rightly referred us to, shouldn't you go first to ICAS?
Our intention is to follow what was provided in previous case law, which is that by addressing this here first, we're just simply raising the issue that if this isn't dealt with at this stage, there is a threat of further proceedings at the Swiss Federal Tribunal. We do deal with this point further along in our submissions.
So this is the answer.
Mr. Arbitrator, I didn't hear you.
So this is the answer.
Yes, that's
So
the answer.
I'm just trying to understand where are you going. Let's assume that we will decide that none of the arbitrators that are challenged will step down. So what will happen? We continue with the hearing, or?
If we continue with the hearing with Mr. Vax and Professor Umaima, we simply submit that there will be a violation of Mr. Atom's right to be heard under Article 6 ECHR. And if that isn't dealt with properly, we have cases which we'll deal with further along, which represent that this will be taken or annulled at a later court. And we simply submit that it is within the CAS's best interest to deal with this at this stage, both for the reputation and dependence of the tribunal.
I understand that you have the obligation to raise immediately when you are informed that a ground exists, but you have to follow also the proper procedures. Can you point us to any provision saying that the panel decides on a challenge brought against one of or two of its members?
Well, in relation to Professor Umaima, we do know that with Article 40.3 of the CAS Code, there is an obligation to confirm their impartiality and independence in a form, which is later ratified by the president of the division. But in relation to the latter point,
but I'm not sure that this was the question of Professor Fumagalli. We are looking for any legal ground basis for us to decide, us, the panel, to decide on a challenge against two of the members of the panel.
So you're asking on the legal basis with how we know the breach of independence and impartiality has occurred?
Not exactly. A point of procedure, not whether there are grounds for a challenge, but on whether we have the power to decide on those with respect to the existence of those grounds.
With reference to that, I do know that the Challenge Commission can remove an arbitrator under Article 35 of the CAS Code and arrange a replacement arbitrator under Article 36 of the CAS Code. And under that basis, that would imply that the CAS does have the procedural authority to carry through what we're asking for today.
Okay. Well, I think you can continue. Subject to the precedents.
Yes, I think we've heard your answers. Please continue with the argument.
Very well. Well, building on that, I would like to discuss Mr. Vax's disqualification and the reasons for it. And we know that the post that he shared on LinkedIn criticizes the COVID-19 anti-vaccination movement, a cause which we know our client has a vested interest in. And again, to further build on the answers to the members of the panel, if I turn your attention to number 13 of the bundle, the IBA guidelines, specifically sections 2B and 2C, we can see that the IBA guidelines provide that an arbitrator must resign if after their appointment relevant facts arise which infer justifiable doubts as to the arbitrator's impartiality or independence. Reading very briefly from the SAM Bundle Exhibit 7, page 14, we see what Mr. Vax has to say about the anti-vaccination movement. It's simple. People who oppose vaccine mandates pose a danger to public health. This free rider attitude is incredibly unfortunate. These are uneducated people who think only about themselves. Now, the content of Exhibit 7 strongly infers an unconscious bias of Mr. Vax towards the appellant. And the implications of a bias arbitrator were addressed by the Federal Supreme Court in Yang against Wada, number 9 in our bundle. Now, in Yang, the CAS order was annulled after it was discovered that the president of the panel issued 3 tweets, which are held to be a breach of impartiality. And this was because the tweets were of a racist nature against the people of China, where the Chinese appellant was from. But of interest, the court held that merely the impression of partiality will justify the disqualification of a judge. And a similar issue did arise in Mutter and Pechstein against Switzerland, which is number 11 in our bundle. But there, Mutter's challenge against the president was rejected due to a lack of evidence. And this is distinguished from our case, with Mr. Vax's LinkedIn post clearly demonstrating this breach of impartiality. Therefore, there's a strong possibility of further proceedings of further proceedings of the Swiss Federal Tribunal if Mr. Vax's disqualification is not dealt with at this stage. We therefore kindly ask the panel to apply the logic and reasoning from the Yang case to the facts at hand.
Counsel, before you continue, I have one question. As far as we understand, the LinkedIn post was made on November 20th, maybe meaning before the constitution of this panel. When the panel was constituted, have you made any due diligence as to the arbitrators, including Mr. Vax?
Madam President, I understand this as a question in relation to duty of curiosity. And the mere fact that information is freely accessible on the internet does not automatically mean that the appellant has failed in our duty of curiosity. Indeed, we assert it is unreasonable to check every post on the internet. LinkedIn is heavily inundated with posts, and one post is simply a needle in a haystack. But it's also unreasonable to assume Mr. Vax has made the comments in the first place. In relation to the point of time, if we refer once more to Yang, the Swiss Federal Tribunal accepted that posts which happened more than a year ago were still admissible.
So have you made any due diligence at the time?
We submit that we have searched and gone extensively as far as we can, Madam President.
Okay, but that was his only post on LinkedIn.
In which case, I'll simply resubmit my point that we cannot be reasonably expected to find an unreasonable comment, just one hidden in the social media, which there are millions of posts every day. But we certainly tried our best, Madam President, and we don't intend to be complacent on this issue.
Okay, thank you.
In the interest of time, I'm going to shift to the next issue in regards to the witness statement. We know that when anonymous witness statements are used, the right to be heard, which is guaranteed by Article 6 ECHR and the Swiss Constitution, Article 29, paragraph 2, is affected. But to mitigate this, a body of ECHR case law provides that the use of anonymous witness statements may be admissible subject to strict conditions. And these conditions are outlined in number 18 of our bundle, reference to paragraph 31. Rather than just listing the 3 criteria, I will apply them straight to the case at hand. What we can see is that 1, the witness was only heard by the Hardlandian judge due to an abstract fear of reprisal. And still keeping with number 18 in our bundle, this time paragraph 29, that provides that an abstract fear is not enough to justify the full anonymity of a witness. In fact, in that same case, number 18, the full anonymity of a witness was denied because there was no concrete evidence which could establish violent threats. On regards to the second limb, the witness was neither questioned by the FIFA Appeal Committee, nor were any checks made on the reliability of their statements. And finally, in relation to the third limb, there was no cross-examination of any kind, let alone audiovisual means, which would have protected the witness's identity. Paragraph 30 of that same case, number 18, also highlighted there that the panel were mindful that the Swiss Federal Tribunal stressed that the tribunal's decision should not be based solely or to a decisive extent on an anonymous witness statement. And consequently, such a mismanaged piece of evidence is of little use to the CAS. In the interest of time, we will briefly allude to the telegram message, and we simply say that instead, the respondent's main evidence is a screenshot of a telegram alleged to originate from the appellant's mobile phone. And you can briefly refer to the SAM bundle, Exhibit 8, page 5, paragraph 22. But there, the FIFA Appeal Committee decision, in a way, was right when they stated that the appellant failed to provide an explanation that the conversation is false. But in the same way, the respondent failed to provide an explanation that the conversation is real. Ultimately, the CAS has absolute discretion regarding proof. And the appellant cannot prove the telegram is a forgery under Article 8 of the Swiss Civil Code. But the inclusion of and large reliance on a questionably sourced piece of evidence poses greater risks to the integrity of the CAS procedure than any perceived risk to the integrity of football. Members of the panel, there ends my submissions, and I'm open to questions, or failing that, I will hand over to my colleague, Mr. Kaluza.
Thank you very much. Does any of my co-arbitrators have any questions still at this point? Okay, yes.
Yes, Madam President, just a question regarding the the statement made by you know what? No, I will leave it to a later stage. Thank you very much. Sorry.
Thank you. Then the floor is for the appellant again for the second part of the pleading.
Thank you, Madam President, members of the tribunal. As formerly introduced, my name is Jakub, and I will submit on issue 4 that the alleged breach of Article 27 has not been proven to the required standard of comfortable satisfaction, and on issue 5 that in case the tribunal finds the breach of Article 27, the imposed sanctions by FIFA were grossly disproportionate and should be reduced. With your permission, I shall begin my submissions on issue 4. That the breach of Article 27 has not been proven to the relevant standard. It is well established principle that it is for the respondent to prove that the appellant committed the acts of bribery to the comfortable satisfaction of the panel, having in mind the seriousness of the allegation made, and that can be found in the case of Teixeira, which is number 5 in the authority list. Paragraph 88. Therefore, It means that the respondent needs to prove 4 requirements of Article 27.1 FIFA Code of Ethics in order to find that the appellant breached this article. And these 4 requirements are as follows. Firstly, that the person is bound by the FIFA Code of Ethics. Secondly, that the person has received an advantage. Thirdly, that this advantage was personal or undue. And fourthly, and finally, that this advantage was obtained in order to obtain or retain business or any other improper advantage. There is no dispute that Mr. Atom is bound by FIFA Code of Ethics. However, the respondent failed and cannot prove with comfortable satisfaction the other 3 requirements. They cannot prove that the appellant accepted an undue advantage in exchange for voting for Hardland in the World Cup bid. This is due to lack of any direct evidence that could reasonably be constitute a basis for such allegations. And obviously the allegations needs to be proven. And in this case, I shall refer to Exhibit 4, the main evidence in this case, the witness statement of an unknown whistleblower. The statement refers to a meeting between Mr. Kaiser and 2 foreign individuals that took place on the 28th of July 2016. Interestingly enough, the witness statement is dated 5th December 2017, which is, according to my calculations, 17 months after the alleged meeting. If I would ask the tribunal members, how much would you remember from a meeting that took place in December 2020, and not even your meeting, but a meeting that you merely observe in the background? I assume that you might struggle with actually remembering a lot of details of that meeting. In this case, however, the respondent decided that the appellant has breached the Article 27, based their opinion on such a long-awaited recollection from a whistleblower. If I can refer your attention to paragraph 13 of this witness statement, this person stated, and that's the last sentence of paragraph 13, I could not identify these individuals as I was just facing their backs. There is no direct evidence leading to Mr. Atom. Following from that, from the Exhibit 4, we learn that the witness heard some pieces of conversation where Mr. Kaiser allegedly rewarded these 2 individuals with modest token of appreciation. It is submitted, members of the tribunal, that this disjoint and very weak evidence cannot be really compared with conclusive evidence in other cases that CAS has already heard. And I shall refer to 2 cases here. The case of Adamu against FIFA, number 20 in the list of authorities, and the case of Fusimalohi against FIFA, number 12 in the list of authorities. In these 2 cases, the FIFA case was based on pages of transcripts and recorded conversations recorded by undercover journalists. In this matter, we are presented with few pages from unknown person, littered with irrelevant quotations, and not substantiated with any other firm evidence. If I can refer again to Exhibit 4, phrases such, please do not touch your wallet, are more than reasonable to say in social circumstances. Similarly, the offer, or Mr. Kaiser's remark to, in terms of TV rights deal division, cannot be treated as serious bribe or an offer, because it was made under influence of alcohol. If I can compare this case to the case of Teixeira, which is number 5 in the bundle, in the list of authorities. In this case, there was also bribery in respect to TV rights allocation. However, in the Teixeira case, it was proven by several witness testimonies, by recordings of phone conversations and emails, and also by details as to the contract. All of the aforementioned was successful in proving the bribery with comfortable satisfaction, simply because it created the whole picture of what actually has happened. In the present case, we are presented with unrelated and unsupported evidence, and we just don't know what happened. I invite the tribunal to follow the approach from the Bin Haman case, number 6 in the list of authorities, where an inconsistent witness report was disregarded and considered as very little help as to decide what might have happened or may not have happened. in case of bribery. In the same case, in paragraph 194, the CAS tribunal agreed that there are multiple plausible scenarios in case the only circumstantial evidence is available. To sum up the issue 4, the respondent's case is like a Swiss cheese. It's just full of holes, and we just don't know the full story. Therefore, it simply cannot be proven to a comfortable satisfaction that the Article 27 has been breached. And members of the tribunal, I am aware that the allocated 22 minutes have passed. However, I would like to ask for additional 3 to 4 minutes for issue 5, simply because of the interventions by my colleague.
We asked a couple of questions to your colleagues, so if my co-arbitrators do not disagree, you would get 3 more minutes. Okay, so please continue.
Thank you, Madam President. I shall move to issue 5 now. So should the tribunal disagree with my submissions on issue 4 and find the breach of Article 27, it is the submission of the appellant that these sanctions should be reduced as they were grossly disproportionate. Firstly, the ban is excessive and contrary to public policy. If I can refer to 2 cases again, the case of Adamo, which is number 20 in the list of authorities, and the case of Platini, which is number 16 in the list of authorities. In both these cases, the bribery was proven to a very prominent figure in FIFA. In the Adamo case, it was a member of executive committee. In the case of Platini, obviously, it was one of the most prominent FIFA persons or UEFA. And in both cases, the fines were much lower than in this case. So in the case of Adamo, the fine was 3 years and 10,000 Swiss francs for a bribe of $800,000. And in Platini, it was 2 million Swiss francs of bribe and only 60,000 Swiss francs and 4-year ban. I refer to these 2 cases where bribes were proven to be more than 40 times higher than in the present proceedings. Yet the sanctions were twice as low as in this case. And I shall ask the panel how these sanctions can be treated reasonable and proportionate. They just simply cannot. Additionally, the combination of 15 years ban and 50,000 Swiss francs poses an excessive limitation on the appellant's economic freedom and is contrary to public policy as stated in the Zaragoza case, which is number 14 in the list of authorities, paragraph 435. Finally, I shall present my last argument that the appeal committee should acknowledge the mitigating circumstances and it failed to do so. And the FIFA appeal committee is required by the Article 9 and 10 of FIFA Code of Ethics to take into account mitigating circumstances. And in this case, Mr. Atom has a clean record, no prior offenses, no repeated breaches. Additionally, the tribunal found that the bribe has been made. It should take into account the fact that Mr. Kaiser actually paid back a significant amount of money to Mr. Kaiser. And while assessing the pecuniary value of sanctions, this should be taken into account. Therefore, if I can ask the panel to reduce the sanctions to 3 years ban and 10,000 Swiss francs, this is submitted to be more proportionate ban sanction. I do apologize. With that being said, this concludes my submissions, and the appellant respectfully invites the tribunal for the following release. Firstly, that the CAS has jurisdiction over the dispute. Secondly, that the challenges against Professor Omaima and Mr. Vax to be upheld. Thirdly, that the anonymous witness statement and telegram evidence should not be admissible. Fourthly, in the event panel does accept the tainted evidence, that we submit that they not amount to comfortable satisfaction of the breach of Article 27. And finally, in the event that the tribunal disagrees with our submission on issue 4, we ask the tribunal to reduce the fine to 3 years and 10,000 Swiss francs. This concludes submissions on behalf of the appellant, unless I can afford any further assistance.
Thank you very much, counsel. I do have indeed 1 or 2 follow-up questions, but I first would like to give the floor to my co-arbitrators and ask them if they have any questions for counsel.
Just a quick question. I would like better to understand what is the relevance of the price. I mean, if an officer is cheap, it means that he is available to give away his virtue for little money. Is that more justifiable than a rich person that is in a position to resist an offer for the same amount because only does not need it? I would like you to explain something more about the impact of the amount and why do you think the amount is relevant to assess the measure of the sanction?
Thank you for this question. The amount of bribe is obviously, I do apologize if I come across as referring that the amount of bribe should be important. The amount of bribe is important in regards to assessing the seriousness of the bribe. Referring to the two cases I used, Adamo and Platini, the gravity of the bribe was important, and the gravity of the influence of the bribe that could have on the FIFA structures. And in the case of in this tribunal, firstly, the bribe was much lower, and secondly, the gravity of the influence that Mr. Atom has only one vote, as compared to Adam when he also got one vote, but it was only 24 committee members. And in this case, there's one vote and 217 federations. So my submission was that it's just simply not as important as it was in two previous cases. So it is just not reasonable to have 3 times higher sanctions for not as serious breach.
Thanks.
Yes, Efraim.
Yes, thank you, Madam President. Just a short question regarding going back for a minute to the challenge against submitted against Mr. Vax, and I see that a lot of emphasis was put in a way referring to the Sun Yang case, the Chinese case. Actually, most of the emphasis was there. And I assume, Mr. Kilgallon, that you read the tweets that were actually published by the president of the panel in this case. Can you really compare those tweets to the one statement made here by Mr. Vax in this case, where the world is divided in between pro and against the vaccinations? Do you consider them really seriously in the same level?
Thank you for that question. I do remember the tweets that were mentioned in Yang. Perhaps it might be best that I don't relay them onto a live stream audience because they are of a slightly.
Well, they are public. They were published, in the award.
Okay, so of course, in that case,
but I will also refrain from quoting them.
Okay, so calling people bastard Sadic Chinese because they're involved in a dog-eating competition, indeed may well be a far overreach and more than satisfy that impression of partiality. But the actual objective standard is the impression of partiality. And what we're looking at here is those remarks that were mentioned in Yang. That's a real hammer blow. But all we're looking for is the impression of partiality. And I do put it to you that if you boil down the principles from the Yang case to the facts in question, what we've got is someone who's in a position of responsibility, objectively putting out some views which are of direct relevance to a cause which our client is involved in. And on that basis, we submit that there is an impression of partiality, which the panel should consider.
Thank you.
Thank you very much. I do have another question regarding the bribery issue. We have understood that regarding the contested testimony, you've put forward arguments as to why the evidence should not be admissible, or at least why it should not have an enhanced evidentiary value. My question is, leaving aside these two pieces of evidence, we have other evidence on the record that you have not yet commented. And I refer you especially to Exhibit 1, which is the email in which the appellant was invited to the trip, and in which it was made very clear that the expenses for the trip would be covered. Given the close proximity of this invitation to the final vote for the World Cup, and also given that in bribery cases, CAS panels have to rely on contextual evidence. Could you please comment on this piece of evidence and why, in your view, it is not sufficient evidence for bribery under Article 27 of the FIFA Code of Ethics?
Thank you for the question, Madam President. Firstly, it is not disputed that this trip has happened. So obviously this email is relevant, but it is not disputed. If I can, the FIFA had almost a year to look for different pieces of evidence to prove to the comfortable satisfaction that Article 27 has been breached. And Article 27 is constructed in such a way that it must be that the beginning and the end of the bribery must be shown. So from the offer to the actual influence on something. In this case, we just know that the trip has been made and been paid for, and it can be argued it's quite common for a bigger federation to pay to support smaller federation, to improve relations, to improve football around the world. But it is simply stated that there is no strong evidence that links this trip to the voting, to the result of voting of FIFA World Cup bid. And therefore, the FIFA failed in proving the required standard. And if I can refer to the required standard, it's much higher threshold than balance of probabilities. So it is not merely enough to say it's likely it has happened. It should be to a higher degree of standard, and that has not been proven.
Yes, Efraim, please turn.
Yes, one more question, and I think that we did not yet, you did not yet touch this point, and if you did, I apologize. Maybe you may have been distracted. But did you explain the pay back of the 20,000 Swiss francs? Why should you pay this amount? If you are so firm in your statements now, saying that there was nothing there, why should the guy run your client and pay the 20,000?
And let me just add one thing. And paying back the 20,000 exactly one day after the criminal convictions happened in Hardland.
Thank you for this question.
Maybe the banks were closed until this day.
Thank you for this question. Unfortunately, I cannot comment on whether banks were closed or not. But what I can comment is I invite the tribunal to again refer to Bin Haman case number 6 in the authority list, to simply say that there are multiple plausible scenarios. It is possible that Mr. Atem paid back 20,000 Swiss francs to Mr. Kaiser for some completely unrelated matter, perhaps for some assistance in something else. We don't know the value of the alleged bribes that the respondent is claiming. So we don't know whether this 20,000 Swiss francs actually could refer to that or not. There is no evidence for that. And that's, again, the weakness of the case of the respondent. They cannot prove that it is actually connected. And therefore, to answer the question, applying the Bin Haman case, in case of lack of the direct evidence and only circumstantial evidence, there are multiple plausible scenarios. So unless the respondent can prove this is the one that is proven to comfortable satisfaction, we just don't know. And if I also can refer to the back payment, that supports the argument that it might be completely not related to the trip in 2016 because it has been made 2 years after this trip. So I just submit that it's irrelevant.
The problem is that whether it is relevant as to the definition of the behavior as a bribe or as a mitigating factor for the application of the sanction.
Thank you for that. obviously, the first submission is the bribe has not happened and the payment is not related. But should the tribunal disagree with the statement and say it is clearly related and the Article 27 has been breached, then I invited in issue 5 to consider that as mitigating circumstances. But obviously, the first one is just not related.
Thank you very much, counsel. Unless there are any other questions by my co-arbitrators, this concludes your mission, and I would pass the floor to counsel for the respondent. You have 22 minutes plus some additional time in case we put questions and therefore prolong your pleading.
Thank you very much. First of all, guten Tag, Frau Rombach, buongiorno, shalom. My name is Luisa Bernasconi. I am counsel for the respondent for FIFA. My colleague is Jascha Trubowitz. I will first be addressing all the procedural issues in this case, and my colleague will then proceed to the merits of this case. As stated in the following, I will address the procedural issues of this case, namely the jurisdiction of CAS, the composition of the tribunal, as well as the admissibility of evidence. As a first issue, we would like to discuss the issue of CAS jurisdiction. Now, according to Article 82, paragraph 1 of the FIFA Code of Ethics, which in the following, just to be clear, we will refer to as FCE, all decisions of the adjudicatory chamber, except for decisions on violations of Article 29 FCE, are final and can only be appealed to CAS. Now, the appellant states that this is in fact a case of Article 29 FCE. This is simply not true. According to paragraph 8 of the appealed decision, and I here refer you to Exhibit 6, the adjudicatory chamber found the appellant guilty of infringements of Article 21, 25, and 27 FCE. So this is simply not a case of Article 29 FCE, I'm sorry. Therefore, if the appellant had intended to challenge the sanction for bribery, he would have had to appeal the adjudicatory chamber's decision not to the FIFA Appeals Committee, but directly to CAS. He did not do this in time. In fact, he did not do this at all. Therefore, the decision of the adjudicatory chamber is today final and binding. In contrast, the appealed decision before us was taken by an instance that was not competent to do so, and is therefore not a final decision in the meaning of Article 57 of the FIFA statutes and R47 of the CAS Code. Now, the appellant tried to convince the panel that he was entitled to rely on the competence of the appeals committee in good faith. However, the appellant cannot rely on good faith. According to the jurisprudence of the Swiss Federal Tribunal and of the CAS, for example, in the case of Cagliari Calcio versus Olimpia Deportivo, with which arbitrator Barak will be very familiar, the CAS held that a party cannot rely on good faith if a simple consultation of the applicable regulations would have shown the proper procedural course. This is especially the case if a party, like the appellant, is assisted by legal counsel. In the present case, Article 82, paragraph 1 FCE is crystal clear. It shows what procedural action the appellant should have taken, but which he failed to do. Therefore, we maintain that CAS does not have jurisdiction to hear this case. I will now continue to address the appellant's challenge against Mr. Vax. As a preliminary issue, I want to clarify.
Excuse me, counsel, sorry to interrupt. I do have one follow-up question on the jurisdictional issue.
Yes, of course.
You cited the applicable principle, but there's another principle that is applicable also under Swiss law, and that principle is venire contra factum proprium. In this case, FIFA, all of this happened within the same body, which is FIFA. FIFA took the case that you now say was not admissible because it should have, the adjudicatory chamber was the final instance. Nevertheless, there is a decision then by the disciplinary chamber, and there is even a note on the legal action which says this decision can be appealed to the Court of Arbitration for Sport. Now, how can FIFA argue that it is not bound by this statement and by the course of actions?
Thank you very much for your question, Ms. Rombach. This is a very good question. Here, I think we have two relevant points. The first question is, who is responsible of taking the proper procedural course? And at the end of the day, each party is responsible that they themselves take the proper procedural course. And as you stated, the information contained on page 13 of the decision, I just want to kind of clarify that the principle that we refer to of Swiss law, that they cannot rely on good faith, this actually stems from the jurisprudence on courts and state authorities that give wrong information. So this would also apply to this case.
Thank you very much. And I apologize. Of course, I was meant to refer to the FIFA Appeals Committee decision.
No
But
worries.
my co-arbitrator, Efraim, you have a follow-up question.
Thank you, Madam President. Ms. Bernasconi, just a question. And again, I'm aware to the fact that this was not raised by the appellant. I'm aware of it. But still, we are the panel and it concerns me. Can you explain me why, in your opinion, because you are FIFA and I'm reading your regulations, why is the appellant, Mr. Aton, in any way subject to the ethics code of ethics of FIFA? Because when I will tell you directly why I'm asking, because when I'm reading the definition of an official, I do not find in any place that the president as such is subject to this code. It says any board member, including members of the council. However, how do I know that the president is a board member? Nobody actually proved it. Or, we know systems in which the presidents are so specific, they are not members of the board.
Thank you very much, Mr. Barak. I here would like to refer you to Article 2 of the FIFA Code of Ethics, which states that simply all officials and players, as well as match agents and intermediaries, fall under.
But we have a definition of official. So I agree with you. Article 2 is clear. Let's try to understand what is an official. So we have to go to the definitions. And I'm just wondering, maybe it's a matter of interpretation. I do not know. But since you are here, I have the opportunity to speak with FIFA.
I mean, I believe that Mr. Atom is the president of Tiny Land Football Federation, so he is the highest, most important member of that federation. And if you look at definition number 2, this would also make him, which also refers to the members associations. So this would also make him an official in this meaning. Does that answer your question?
This is an answer. Whether it answers my question or not, I do not know, but this is an answer. Thank you.
Thank you very much, Mr. Barak.
Thank you very much. So, Ms. Bernasconi, please continue.
Thank you very much. So I will now turn to the appellant's challenge of Mr. Vax. And as a preliminary issue, I just want to clarify that we understand that the appellant wants to voice his objections on the composition of the tribunal, but that this is the wrong forum to do so. As pointed out by arbitrator Barak, the challenge should have been brought before ICAS, who's the only instance that has the power on such challenges. In order, however, to be complete, I will still forward our submissions on this point. Dear panel, the appellant's challenge of the presiding arbitrator must be dismissed. According to Article R34 of the CAS Code, challenges have to be brought within 7 days after the ground of the challenge was or should have become known. As you can see in Exhibit 7, the basis of the appellant's challenge is a LinkedIn comment published by Mr. Vax on 20 November 2021. Only 3 days ago, after waiting almost 4 months after Mr. Vax made this comment, the appellant decided to raise this issue. It is therefore out of question that the appellant is not in compliance with the 7-day time limit. Dear panel, in the case at hand, there is no justification for such a belated challenge. The Swiss lex arbitri, namely Article 180, paragraph 2 of the Swiss Private International Law Act, imposes a duty of curiosity on the parties. This requires the parties to investigate potential circumstances that may impair the impartiality or the independence of the arbitrators. What does this mean in practical terms? As the Swiss Federal Tribunal held in the Sunyang case, already cited by the appellant, it means that the parties have to consult all sources that are likely to provide elements revealing a possible risk of bias. Dear panel, LinkedIn is exactly such a source. It is a social network which specifically serves the purpose of publicly sharing a person's current and previous professional activity. Hence, with all due respect, if the appellant did not look at the arbitrator's LinkedIn profiles, the appellant quite simply failed to carry out the most basic due diligence. Additionally, the appellant claims that the LinkedIn comment was a so-called needle in a haystack. This is simply wrong. As the president pointed out, this was Mr. Wax's only comment on LinkedIn. And if you look at a person's LinkedIn profiles, a person's activity, namely their comments and posts, etc., are the first thing you see when you look at their profiles. So to say that it was not possible to find this comment is a very far-fetched excuse for this late challenge. It is therefore clear that the appellant has not fulfilled his duty of curiosity and the challenge is belated. In any event, the facts do not meet the threshold for challenging an arbitrator. I refer you again to Exhibit 7. What does Mr. Wax actually say here? Mr. Wax's comment simply reflects the statement of public health official. As even acknowledged by the appellant, this comment is in no way comparable to the extremely violent statements made by the arbitrator in the Sunyang case. Additionally, the comment is highly generalized and no personal animus is shown to the appellant. This is especially the case since the comment, as even pointed out by Madam President, was actually published before Mr. Wax was appointed as president of this panel. Hence, the only conclusion to be taken from this comment is that these two individuals have two different opinions regarding this specific topic, which has nothing to do with the dispute at hand. Now, esteemed members of the panel, should this alone exclude the presiding arbitrator from acting on this panel? No, it should not. If Mr. Wax's general comment on a current political matter were to exclude him from acting as an arbitrator, this would mean that arbitrators in general can never voice their opinions on any topic online. This cannot reasonably be expected. I have now explained to the panel why the appellant's challenge of Mr. Wax is not only belated, but also unjustified and must therefore be dismissed. Now, since the appellant did not raise any doubts about any other arbitrators, and we don't have any objections either, I would just like to express that we are very grateful for all of the arbitrators' availability to hear this very important case. Now, before entering into the details of this case, I want to remind the panel what this case is actually about. The appellant is the most important custodian of football in Tinyland, being the president of the Football Federation, and he should therefore be held to the highest standard. The appellant has betrayed football by getting involved into a bribery scheme to rig the 2026 World Cup election. This momentous decision has distorted the election and cannot remain without consequences if we want to preserve the integrity of the beautiful game of football. Dear panel, I will now go into the details of this case, beginning with the very important evidentiary issues. To mirror the appellant's structure, I will first address the so-called witness statement and then the telegram messages. The first piece of evidence contested by the appellant is the statement from the Hardlandian criminal proceedings. And I here refer the panel to Exhibit 4. Esteemed members of the panel, the appellant spent a lot of time talking about why the whistleblower should not be allowed as an anonymous witness in this case. However, this completely misses the point, since the whistleblower quite simply is not a witness in these proceedings. There cannot be a violation of the right to cross-examination if there is no witness to cross-examine. Having said that, the CAS has held, for example, in paragraph 92 of the award of Ricardo Teixeira versus FIFA, which Mr. Fumagalli will be very familiar with, that written testimonies are admissible evidence. In such a case, a testimony is simply not regarded as a witness statement, but is admitted as documentary evidence. In paragraph 99 of the same decision, the CAS even confirmed that testimonies from criminal proceedings can be attributed significant evidentiary weight. The basis for this conclusion was the fact that the witnesses had been subject to an inquisitive examination and that their testimony had led to conviction beyond reasonable doubt. Now, the exact same thing is true in this case. The whistleblower was examined by the Hadlandian judge, and his testimony led to the conviction of 5 football officials beyond reasonable doubt. Hence, CAS jurisprudence shows us 2 things. Firstly,
if I may, sorry for interrupting, but as far as I can understand, the judge in the National Court actually had the full text of the affidavit. Am I right?
We do not have this information, but I think we can assume that.
So, and it doesn't make any difference to you. I'll just give you an example. Let's assume for a minute that in Article 1 that was redacted, I do not know what was written in Article 1. What the witness said is that he was at the same evening in the restaurant, he witnessed that Mr. Kaiser gave a loan to Mr. Atton because he needed a loan of 20,000 Swiss francs for 2 or 3 months to buy something. And this will explain now the payback of the 20,000. Do you think that it may be relevant? Question 1. Question 2. Maybe it was because of Article 1 that is redacted that Mr. Atton was not charged in the national case. Possibility. So I'm trying to understand, because you put a lot of, and rightly so, you put a lot of emphasis in this document. But the problem that we have is that even according to, as far as I remember, at least 2 cases of the CAS jurisprudence, I'm not sure that it would have been admissible in other CAS proceedings, such an affidavit.
Thank you very much, Mr. Barak, for your question. Just to make sure I understood it correctly. So your question is whether it has any influence that the statement is redacted. Is
Yes.
that the question? So the statement was redacted in order to protect the witness, and this was necessary. Of course, we are not aware who this witness is. We are not aware what the rest of the statement says, but I believe that the judge must have had good reasons to redact this in order to protect the witness. Now, does this have an influence on the admissibility? No, it has not, because as stated, in the Ricardo Teixeira case, the deciding factor was that the witnesses have been questioned, and this is the same thing here. If you look at paragraph 17 of Annex 1 of the procedural order, I believe it states that the witness had been questioned by the judge. So this makes this a very valid statement, even though it is redacted in some parts in order to protect the witness's identity.
Yeah, but he was asked by the judge, but not by us. I can understand the idea of the protection, but should he be protected also from us, the panel, at least us, the panel? As far as I remember, in the CAS jurisprudence, at least in 2 cases, in the Poveda case, in the Contador case, it was very clear that the panel said that if the minimum is that the witness should be revealed, the identity of the witness should be revealed to the panel alone. The panel at least should know whether we are speaking with a person or maybe with a bot, or I don't know with what.
Well, that is a very valid point. The difference in these cases is that in those cases, there was an anonymous witness, there was a person. In this case, unfortunately, we as FIFA also, we don't know who this person is, so we were not able to call this person. So that is the difference. If there is an actual person, then of course we don't deny.
So why do we have this affidavit in our file? Did FIFA rely on this document when coming to its decision or not?
We did rely on this document. But we simply did not know the identity of the witness. I just want to, again, I'm not sure if I was clear enough. We regard this as documentary evidence and not as a witness statement per se. And in such, at the end of the day, it's a piece of documentary evidence. So the fact whether
So it's more or less the same way that you could have bring, let's say, an article of a newspaper.
I think, yes, the same way we could have brought an article of a newspaper. However, the content and the background of this statement makes this quite different from simply a newspaper article. Because, as exactly stated in the Teixeira case, even if such statements are admitted as documentary evidence, they have significant evidentiary weight if they stem from criminal proceedings.
Thank you.
Thank you very much. May I?
Yes, please continue.
Thank you very much. So just to conclude on the evidence, the second piece of evidence contested by the appellant are the telegram messages, and I here refer the panel to Exhibit 5. Here I just want to make two very short points. First of all, that the admissibility of evidence in this case is regulated in Article 46 of the FIFA Code of Ethics, which states that generally all evidence is admissible unless it has been obtained by means or ways involving violations of human dignity or obviously does not serve to establish relevant facts. Now, the admission of telegram messages in these proceedings does not constitute a violation of human dignity, as this is only reserved for the most appalling infringements of humanity per se. And therefore, in application of Article 46 FCE, the telegram messages are admissible. This result is also underlined by previous CAS jurisprudence on the issue of illegally obtained evidence. I here refer the panel to the decision of Manchester City FC versus UEFA, in which the CAS admitted hacked emails as evidence. And here the panel relied heavily on the fact that UEFA itself, like the respondent in this case, was not involved in the obtaining of the emails, but had obtained them from a third party. Additionally, the tribunal stressed that the public interest to uncover the truth generally prevails over any opposing personal interests. Lastly, just to conclude, the appellant raises the issue of the authenticity of the telegram messages. And I here want to remind the panel that the appellant bears the burden of proof when claiming the falsification of a document. The CAS held in the case of Ricardo Terra Teixeira versus FIFA, and I quote, "The onus of proof remains on FIFA, but the evidential burden of contesting the facts admitted by FIFA and deducing evidence shifts to the appellant." As was shown in the Manchester City versus UEFA case, the only way to fulfill this burden is for the appellant to share with the tribunal the real content of his telegram messages. I hereby conclude my submissions and give the floor to my colleague Jascha.
Thank you very much, Ms. Bernasconi.
Good day. Before I get started on my submission, I'd just like to request an additional 10 minutes so I may make my submission in a coherent fashion. Is that all right?
An additional 10 minutes, you said?
We've now reached 21 minutes and 43 seconds, and the questions that were posed, all combined, were added up to roughly 10 minutes.
That would probably give you more time than the appellants had. I would ask the appellants on commenting on this request.
Jakub, do you want to go?
If we can just ask for the longer time for rebuttal in this case, if we were to address any issues, that would be, I think, fair.
Yes, respondent, counsel for respondent.
That's reasonable.
Okay, so do you have any idea of how long your rebuttal you would like to have?
I cannot really say right now, but I think 4 minutes should be enough.
Okay, if respondent agrees that we extend the rebuttal of the appellant to 4 minutes, then I would invite you to continue now, and you have 10 additional minutes.
Thank you very much. Esteemed members of the panel, it is the respondent's position that the appellant breached Article 27 FC and that the imposed sanctions are indeed proportionate given the appellant's very serious misconduct. Before going into the details of Article 27 FC, I will briefly reiterate which standard of proof applies. As per Article 48 FC, the standard of proof of comfortable satisfaction is applied in FIFA ethics proceedings. Now, contrary to the appellant's argument, indirect evidence may be relied upon. This has been confirmed by the cases of Osiris Guzman versus FIFA and Marco Polo de Nero versus FIFA. Especially in the panel in Osiris Guzman versus FIFA explained in reference to cost disciplinary and integrity cases, and I quote, "Those cases must be solved on the basis of a comfortable satisfaction of the respective panel without the necessity of direct evidence." So in conclusion, the panel only has to be comfortably satisfied as to the bribery charges against the appellant and does not need direct evidence to reach its conviction. Now, coming to the heart of the matter, how have the appellant's actions breached Article 27 FCE? I will briefly establish the requirements under Article 27, the critical, let's say, requirements. First, the appellant has to have accepted a personal or undue pecuniary or other advantage. And, first, and second, as a service in return, the appellant has to have executed an official act which falls within his discretion. Dear panel, we will show that Mr. Atom accepted financial advantages from Mr. Kaiser, and in return, Mr. Atom voted for Big Land in the 2026 World Cup election. The starting point of this bribery scheme is Exhibit 1. I refer the panel to this exhibit. It is an email from Mr. Kaiser to Mr. Atom and his business associate, Mr. Lenders. As you can see, Mr. Kaiser invited Mr. Atom to Big Land to discuss alleged business opportunities between the federations of Tiny Land and Big Land. The trip cost being completely free must have piqued Mr. Atom's interest. This gift, including a business class trip to Big Land, as shown in Exhibit 2, turned out to be the very beginning of Mr. Atom's trip of indulgence in Big Land. What happened next on this trip is what the appellant is eagerly trying to suppress in its submission by arguing that Exhibit 4, the witness statement, is not credible. Let me first explain why Exhibit 4 is credible, contrary to all the appellant's assertions. The evening of 28th of July, 2016 wasn't just any evening, but a particularly memorable one for the witness. First, the witness was celebrating an important milestone in his or her business. Second, Mr. Kaiser is a very prominent figure in Big Land and was conducting a very unusual and sketchy conversation. This must have remained firmly in the witness's memory. Finally, the witness statement contains a statement of truth. Providing a false statement of truth in criminal proceedings may lead to criminal prosecution. Therefore, the witness statement should be regarded as credible. Moreover, although the witness... Oh.
Sorry, Mr. Trubowitz, you
Yes.
said that there was a firm recollection of the witness regarding the statement or whatever made by Mr. Atom. Did you say something like this? Looking at the witness statement?
I said that the recollections of the witness of what occurred on the evening of the 28th July 2016 are credible due to various reasons. That's what I said.
Yeah, but he did not identify the individuals.
I will get to that immediately. Mr. Arbitrator.
No, we are speaking about the case of Mr. Atom, not
I understand completely. I get
a hypothetical case of someone walking
some random individual. No,
okay,
not
so
at all.
you should show, convince.
I will establish this.
Comfortably convince us that this statement actually deals with Mr. Atom.
I'm happy to do this immediately.
This is my comfortable. This is what I would need for a comfortable satisfaction. Thank you.
So, now, to address this point, so although the witness could not identify the two individuals from Tiny Land, it was clear that he was joined by Mr. Atom and Mr. Lenders. And this is, first of all, supported by the facts. On the facts page, para 3, it says that that Mr. Kaiser invited the appellant and Mr. Lenders for dinner. Furthermore, according to the witness statement, the discussions involved football-related issues such as the World Cup and the friendly match between Tiny Land and Big Land. So this we can very much infer from this that the two individuals that Mr. Kaiser was speaking to on the 28th July 2016 are in fact Mr. Atom and Mr. Lenders. Now, what do we learn from the witness statement on which the appellant has remained silent?
So your assumption is that on that evening, Mr. Kaiser met in the restaurant only these two individuals. There was no one else in the restaurant.
The restaurant, no. So Mr. Kaiser only met these two individuals in this restaurant, but the restaurant contained obviously other individuals, such as the witness was also there at this restaurant.
But maybe also Article 1 of the redacted Article 1 speaks about the meeting with other people on same date, on same restaurant, on same evening.
I think from the witness statement, it's clear that the first point concerns some other matter that's not related, and the second point concerns the evening of the.
How do we know that it's not related? How can you say that it's not related?
I think from the witness statement.
Did you see the full affidavit, or you saw only the redacted version?
We've only us from FIFA have only received this document from the Hardlandian criminal proceedings.
And it is redacted.
And it is in this redacted form, indeed.
Okay, thank you. Sorry, continue, please.
Thank you very much. Now, what do we learn from the witness statement on which the appellant has remained silent, partially silent at least? The appellant's trip turned out to be a lavish, all-inclusive, luxurious stay, topped off with an expensive dinner at the famous Michelin star restaurant Nostimon, and a night of clubbing at the most luxurious club in fancy capital. Mr. Kaiser even handed him an expensive watch. Conducting actual business appeared to be the last thing on the appellant's mind. The appellant thus accepted personal financial advantages. What is left to show is that the appellant, in return for these advantages, executed an official act. And I refer the panel to Exhibit 5. This shows the telegram messages between Mr. Atom and Mr. Lenders discussing their crazy nights in Bigland. I would like to draw your attention to the last two messages. Mr. Atom writes, "Yeah, I've thought about it. After all they did for us, the least we can do is vote for them." To this, Mr. Lenders replies, "Yep, agreed. We cannot draw back now." Dear panel, let that sink in. After all they did for us. Now, what does this show us about the appellant's mindset? The appellant is not concerned at all about what is best for the game of football, but solely sees the vote as a quid pro quo for his financial benefits. The phrasing, "we cannot draw back now," shows that the appellant made a commitment to Mr. Kaiser to vote for Bigland in the 2026 World Cup election. This shows an obvious quid pro quo between the advantage and the appellant's conduct. I would like to just address one more piece of evidence, namely Exhibit 3. It shows that the appellant wired 20,000 Swiss francs to Mr. Kaiser. The transfer is dated, indeed, on the 8th of September 2018, more than 2 years after the appellant's trip to Bigland. What motivated the appellant to make this money transfer on this specific date? A day earlier, a Hardlandian judge had convicted 5 football officials, as well as Mr. Kaiser, of being involved in a bribery scheme to vote for Bigland. That others got caught for bribery must have absolutely terrified the appellant. The rushed money transfer shows that the appellant knew that strings were attached to the benefits he received from Mr. Kaiser. The misleading reimbursement can only be regarded as what it is, an admission of guilt. In conclusion, let's quickly reiterate how the appellant fulfilled Article 27. Mr. Adam accepted financial advantages from Mr. Kaiser, and in return for this, voted for Bigland in the 2026 World Cup election. Dear panel, as the last issue, I will now address the sanctions imposed on the appellant. In the following, I will demonstrate why the sanctions, the 15-year ban and the 50,000 Swiss francs imposed on the appellant, are not grossly disproportionate, and why, therefore, this panel must refrain from reviewing this sanction. CAS jurisprudence has introduced a high threshold for restraining the discretionary powers of sports bodies. Sanctions should only be reviewed when they are evidently and grossly disproportionate. First of all, the imposed ban does not breach Swiss law nor public policy. The appellant appears to rely on Zaragoza and Matusalem versus FIFA. The appellant conveniently admits that this case concerned a football player who was severally liable to damages of around 12 million euros, a debt so high that a ban for an unlimited period would deprive the football player from his economic activity to repay the debt. This is simply a different fact pattern to the present case. Second, contrary to the appellant's claims, the reimbursement has already been factored in the level of sanctions. In fact, the minimum sanction of 100,000 Swiss francs, as prescribed by Article 27, paragraph 3, has already been reduced by half. Third, The appellant suggests his long history of service to football and his good record should be a mitigating factor. If anything, this should be considered an aggravating factor. As the panel in Marco Polo Del Nero versus FIFA held, experience and seniority meant that the offender had an even greater duty to act within the rules applicable to him. Finally, the appellant cites the decades-old case of Amos Adamo versus FIFA, which should not be used as guiding case law. There's been an evolution in the jurisprudence of FIFA since the corruption scandals of Blatter and Platini. Against this backdrop, I'll now tell you why the appellant's proposed sanctions are inappropriate. In the recent bribery cases of Kwesi Intaki versus FIFA and Ricardo Terra Teixeira versus FIFA, the offenders were given a 15-year, respectively a lifetime ban. Dear panel, you may ask yourself why a 15-year ban in this specific case is justified. The appellant sold his vote to Big Land. This is a grave violation of democratic process, and not just any democratic process, but for the selection of the location of the most prestigious football tournament in the world. A 15-year ban is necessary to deter future football officials from doing the same, to protect the integrity of the game of football and to ensure the public's trust in FIFA's democratic processes. Finally, Article 27, paragraph 3 of the FC clearly states that persons holding high positions should be sanctioned tougher. With great power comes great responsibility. In summary, the 15-year ban and the 50,000 Swiss franc fine imposed on the appellant are proportionate. Therefore, this panel must refrain from reviewing this sanction. To conclude my submission, I want to reiterate the following. The appellant received financial advantages and in return voted for Big Land. Mr. Atom, one of the custodians of football, thus committed bribery. Such conduct cannot be left without consequences to preserve the integrity of the beautiful game. We therefore ask the panel to dismiss this appeal. Thank you.
Thank you very much, Counsel for Respondent. Are there any questions by my co-arbitrators? No further. I do have one further question, Mr. Trubowitz. Could you please explain to me what is the main purpose of the sanction in the present case? You mentioned the purpose of deterrence. Is that what the main purpose for this, for putting a 15-year ban on the appellant, or what is the purpose of the sanction?
So sanctions have to confirm or have a number of factors to consider. And in this specific case, the deterrent effect should be given additional weight given the conduct on part of the appellant. I would also, in this case, refer to other case laws, such as Vernon Manilo Fernando versus FIFA, which also concerned a democratic process, a football democratic process, where the appellant, where the offender was given a lifetime ban. So I would say, or would argue that especially when it affects a democratic process, that the offender should be given a high sanction in order for it to have a sufficient deterrent effect.
Okay, thank you very much. Okay, if there are no further questions, okay, there's one more question, please.
I always have one more question. Two questions, actually, Mr. Trubowitz. Can you explain the 20,000? How come you came to the understanding that 20,000 in a way was the payback of the expenses?
So I'll refer to, this is Exhibit 3 that you are referring to. And first of all, it says on this piece of evidence, it says concept, it says reimbursement. So there is the intention to reimburse a certain sum that had been given to him priorly. Now the question is, what do the 20,000 Swiss francs reflect?
Mm-hmm. Yes.
So it's our understanding that the flight tickets as well as the hotel stay in Big Land amounted to 9,750 francs for Mr. Atom.
9,500.
9,000.
The flight tickets and the hotel 19,500.
For both individuals, indeed.
So
indeed.
What is the 500? Tip?
I imagine the Mr. Atom simply wanted a flat number.
We do not in such a case, we do not imagine. We have to understand. Do you have any understanding why did he pay 20,000 instead of 19,500?
We are not given any indication in the case what the additional 500 is.
Maybe the indication was in point 1 that was redacted, Article 1 of the affidavit.
We don't know about this, most certainly. There are many various reasons that he included an additional 500 Swiss francs, could be for reasons of interest. We do not know, but it could be.
Okay, and last question. I promise that this is the last question. And I understand that you are under the clear understanding that this reimbursement was paying back because he was afraid following the decision of the court. I totally understand your way of thinking. Is it reasonable to you that in such case, what Mr. Atten will do is run to the bank and make an official open transfer recorded that anyone can find it easily? Does it make sense? Does it make sense to you?
First of all, it's not that anyone could find it. It was a direct payment from Mr. Atten to Mr. Kaiser. So it was not public, it was private.
But the records, well, let's say the records are easy to trace. Okay.
Well, I mean, I imagine such a bank statement is usually.
Let's say when I take bribery and I pay it back, I will never do it to an official bank transfer. Believe me.
We don't know what Mr. Atten was thinking at the time, obviously, but it's clear from the document that he did mean to conceal it because it was directly sent to Mr. Kaiser, and there's no official record otherwise.
Thank you.
Thank you very much. Then let's move on to the rebuttals. And as agreed, the appellant now has the floor with a 4-minute rebuttal, please.
Madam President, members of the panel, thank you very much for your patience with the timings today. Mr. Kaluza, I know I have 3 points to make, and I'll leave the floor with you afterwards. So earlier we heard the respondent say that there had not in fact been a violation of Article 29 of the FIFA Code of Ethics in relation to a manipulation of a competition. Well, we simply submit that is not correct. And actually, that if you go back to the previous decisions of the Ethics Chamber and Adjudicator Chamber, that would be one of the many omissions and errors that they made. For instance, they also didn't hear the witness for the reasons that we've heard earlier with the alleged breaches of Article 6 ECHR. But I'd also mention that with Article 58, paragraph 3 of the FIFA statute, disputes shall be taken to an independent and duly constituted arbitration tribunal. And it is well established that the Ethics and Appeal Committee are not arbitral tribunals. In relation to the arbitrations challenge, the 7-day window was in fact met because we challenged that decision once we were aware of the LinkedIn post in accordance with R34 of the CAS code. And very simply, in a world of online hearings, think of the ease with which we've organized this hearing today. It's never been easier to substitute or replace an arbitrator, of which there are 380 currently in the queue. And in terms of the witness statement and the admissibility of it, the respondents are right to call the witness statement as an evidential document of lower value, say for instance, on a similar level as the Jerusalem Post. But with reference to number 8 of our bundle, paragraph 20I, that also confirms this. And the witness statement would have been of much more value had they have followed the guidance as applied in Keramudin, where Afghan witnesses were brought to a panel and they were cross-examined by audiovisual means. Mr. Kaluza, that's 2 minutes done from me, and it's over to you.
Thank you, Jonny. Members of the tribunal, I shall just address a few issues. It's never been stated by me that the circumstantial evidence cannot be relied upon. It was stated that they just not strong evidence, and in case they are the only evidence, this case is really weak. And the counsel for the respondent stated that the witness statement is a credible, even though they already accepted it shouldn't be treated as a witness statement at all. So I don't know why they're referring to it as a witness statement. And it was also made under the influence of alcohol, because as the counsel rightly observed, it was celebration time. It's not credible at all. If I can also raise your attention, in the in the submissions on behalf of the respondent, it was stated that bribery is by very nature a concealed action. So why would anyone try to discuss bribery in one of the best restaurants in the country? It's just unreasonable to assume so. Finally, I shall just refer to the mitigating argument on behalf of the respondent. There is Article 9 and 10 of FIFA Code of Ethics that requires the FIFA to consider mitigating circumstances, and they need to be taken into account. And you cannot simply say that they should be treated as aggravating. It's just a difficult argument to understand. And finally, I would refer to the final questions of the counsel for the respondent when he for several times stated, "We don't know, we are not sure." It just shows that the respondent has no strong case. They just don't know what happened and they speculate in this matter. And that concludes the rebuttal on behalf of the appellant. Thank you.
Thank you very much, Mr. Kaluza. Now we come to the rebuttal of the respondent, and as agreed in the beginning, you do have 90 seconds now for your rebuttal.
Thank you very much, Ms. Rombach. I just want to address 3 points quite shortly. Again, the appellant states that this is in fact a case of Article 29 FC, which simply is not. Even if it were to somehow fall under Article 29 FC, this was not the issue of this case. I can only repeat, the adjudicatory chamber found the appellant guilty of infringements of Article 21, 25, and 27 FCE. It's as simple as that. This is not a case of Article 29 FCE, and it doesn't matter what has been decided in other cases. Secondly, the appellant states that his challenge was timely, and I here just want to state again that it is commonly accepted that the time limit runs 7 days from the time at which, yes, the ground for the challenge was known or should have become known. Otherwise, why would the duty of curiosity exist? Otherwise, you could always wait, and as soon as something comes up, even if you should have seen it ages ago, you can bring it up now and it's no worries. So this is not, the appellant's challenge was clearly not timely. Lastly, the appellant states again that the reimbursement should be taken into account as a mitigating factor. And here we just want to state again that it obviously has already been taken into account, since the minimum sanction is 100 Swiss francs and the sanction imposed on the appellant here was a 50,000 Swiss francs, so it was already reduced by half. Thank you very much.
Thank you very much, Ms. Bernasconi. Now this concludes the hearing. Unless there are any other questions or remarks, which seems not to be the case, then for just for the record, I would like each of the appellant and the respondent to confirm that their right to be heard has been respected in today's hearings and that they have no challenge to make in this respect.
I can confirm that, Madam President. No objections.
No objections from our side either. Thank you very much.
Okay, thank you.